Make sure everybody can hear me. Just want to say good afternoon. I appreciate everyone who made it here today. For weeks, my office has received reports of misconduct, malfeasance, and unethical behavior regarding the St. Louis City Sheriff. After launching our investigation and reviewing a growing quantum of evidence substantiating these allegations, I was left with no choice but to take the appropriate legal action. As a result of the sheriff's failure to discharge his legal and ethical duties, yesterday I demanded that Montgomery resign, vacate his office immediately, or face removal proceedings. I gave him the chance to do what is right by the people of St. Louis, and he declined while refusing to deny any of the state's allegations. It's noteworthy that these are allegations he has previously admitted to on social media and in interviews. At 12:01 p.m. today, my office filed an 87-page writ of quo warranto and initiated the process to remove him from office. This constitutes more than 140 paragraphs of factual and legal allegations that all lead to the conclusion that Montgomery has forfeited his office. The decision to exercise this long-held authority is one of the toughest decisions that I ever have to make as the top legal officer of the state of Missouri. I am pursuing a quo warranto because Missouri, and specifically St. Louis, deserves effective leadership and confidence in our public institutions. This is about restoring the rule of law. Failing to perform your duties, exceeding your jurisdiction, terrorizing employees, or frivolously wasting taxpayer dollars undermines public confidence in our governmental institutions. Montgomery has betrayed the people of St. Louis since day one in office, and our quo lists 6 distinct counts highlighting his pervasive negligence and misconduct. Each count is significant enough to warrant removal from office. I'm going to outline the counts for you, and this document will be available. It's at courts.mo.gov on CaseNet. Count 1, nepotism. Montgomery hired a family member, his brother, to work as a deputy. This is an outright violation of the Missouri Constitution. By operation of constitutional law, this misbehavior alone causes his forfeiture of office. Count 2, the illegal arrest of acting jail commissioner Tammy Ross. Montgomery illegally compelled his deputies to arrest the acting jail commissioner while she was in performance of her official duties, and full well with the knowledge that he and his deputies do not have the statutory authority to make this kind of arrest. Count 3, the illegal arrest and disarmament of Darrell Wilson. Montgomery illegally arrested a lawfully licensed private security guard and seized his firearm. As stated, there is no Missouri statute authorizing Montgomery to make this kind of arrest or deprive this individual of their constitutionally protected rights. Moreover, state statute explicitly prohibits Montgomery from enforcing the general criminal code, and his actions have directly undermined public safety. Count 4, his failure to transport inmates for crucial medical and mental health treatment. Montgomery has refused his legal obligation to transport inmates for medical and mental health treatments 59 times since taking office, the first dereliction of duty occurring less than 15 hours after he became sheriff. Not only has he publicly stated it's his duty, but statute requires him to perform the tasks historically performed by his office, and prisoner transport has been part of that list of duties for several decades. The critical task is clearly outlined in agreements that predate Montgomery taking office. This has nothing to do with the 8th Amendment requirements placed on custodians of inmates, and everything to do with the specific statutory and legal obligations of his office. Count 5, illegal and fraudulent use of his office for personal gain. Montgomery has abused his authority and resources repeatedly for his own personal benefit. One particularly egregious example includes utilizing his employees as babysitters and directing them to use office vehicles to pick up his children from school and bring them to his office. We're not talking about a singular isolated incident. He is running a taxpayer-funded personal private daycare in his office and using his staff and city taxpayer resources. Count 6, financial mismanagement of the office. Montgomery has wasted tens of thousands of dollars on unnecessary expenses, golf carts, gold-plated badges, a new take-home Chevrolet Tahoe, and robots. Not to mention, he has hired attorneys beyond those authorized to his office and statute. Moreover, in his request for budget increases to cover these expenditures, he has not been honest in his representation to the Board of Aldermen or the people of the city of St. Louis. This level of misconduct and instability demands immediate accountability. Law enforcement officers in St. Louis need and deserve the support of a leader who will stand by them, not one who abandons his duties less than 15 hours after taking office. It is time to restore confidence and credibility in our elected officials and the rule of law, not just in the seat of St. Louis, but across the great state of Missouri. These actions are the result of an ongoing investigation, and as we uncover additional instances of negligence and misconduct, we intend to expand our complaint in our petition as needed. To that end, my office has established a tip line for whistleblowers and affected members of the public. If you have any information regarding Sheriff Montgomery, please email my office at stlcorruption@ago.mo.gov. That's stlcorruption@ago.mo.gov. The Missouri Attorney General's office maintains a zero-tolerance policy for public corruptions and malfeasance. This writ of quo warranto, similar to previous actions we have taken, sends a clear message that Missouri will always hold those who refuse to uphold the rule of law accountable. Our mission doesn't end here. We are ready to stand in the gap of any elected official who refuses to uphold their oath of office, and we will not back down. And at this time, I believe we'll take some questions.
You said each count is significant enough to warrant removal, but was there one that was a tipping point, one that said, I got to take action?
You know, the constitutional nepotism violation has historically been an impetus for other previous administrations in the Attorney General's office to take action. Between that and the false arrests, those alone are grave and significant. But again, I submit to you that each of these counts standing alone warrants removal from office.
The false Montgomery said yesterday that this is just based on media reports and that you don't have facts and evidence. Can you share some of the evidence that led you to these counts?
Yeah, certainly. We've conducted independent investigation that includes retrieval of documents, interviews within the last 24 hours. Our tip line has already resulted in numerous instances of citizens opining that warrant significant follow-up investigation. So the citizenry is already reporting additional instances of misconduct and providing additional evidence. But I would say you need look no further than his own statements in admitting to most of these allegations himself on his social media pages and in interviews.
On the jail transfer side, the judge yesterday, his lawyer, said that they haven't actually denied any transport. They're in the process of a budget dispute, basically.
Yeah.
Why is that your fight? And I mean, the Attorney General's office has argued this same thing for the Department of Corrections, for jails all over the place. Why is the budget dispute at the city level your fight?
The budget dispute is not. His refusal to comply with the statute that requires him to perform duties traditionally associated with this office, which include prisoner transport for needed health care. Is that statutory violation is the impetus for the claim.
The Board of Aldermen is currently in the process of clarifying the city ordinances to clear that up. Aren't you getting out in front of that?
No, because there's documented pre-existing relationships committing the sheriff's office to that as a traditional duty. And I would submit to you that the sheriff's own statements oftentimes indicate he's aware of that duty and aware it's his office's responsibility.
The sheriff saying that there's a 3-page document he handed out to me yesterday. It's a contract that he says as far as January of this year that the city acknowledges that it's the city's responsibility to transport those inmates. Responsibility if something happened to an inmate in the custody would be on them, not the city. It should be the city's responsibility. Is that deal not valid?
Yeah, look, I'm happy to review that. We're happy to review that in relation to this claim, and certainly I anticipate he'll put that on as a defense. But what we have is evidence that the sheriff's office has previously committed as one of its traditional duties under the statute to transport criminals and if he doesn't want to do it, he needs to go be explicit and get that changed in writing, in memorialization, so that we don't run into these kinds of problems.
How long does this process take? I mean, how big of a priority is this for you to settle?
This is a priority, and my hope would be that Sheriff Montgomery would see the light and do the right thing and resign immediately. We tried to give him that opportunity yesterday, but at the end of the day, the court process will move as quickly as we can get a judge assigned and as quickly as the umpire can call the game, essentially.
If you could put your legal analyst hat on for a minute, it's a pretty high standard to prove willful neglect, malfeasance, isn't it? I mean, how hard is this going to be to prove in court?
Well, I think that each of these, if we can prove the facts that we make in our counts, then each one alone would justify removal. And we have to prove them by preponderance of the evidence. under the civil standard of law. So we are prepared to move forward. We believe we have the evidence, and I think we're going to have more evidence. We saw this with the Gardner case, when as soon as we launched, citizens began reporting in that they had additional evidence, and that's already happened within the last 24 hours. We anticipate that will continue to happen for the next several days.
Dennis Hancock had a clear violation. Dennis Hancock had a nepotism hire. You didn't pursue quo warranto proceedings against him. Is that because he's a Republican?
Happy to look at that case.
We'll go Elliot, then one last question.
Yeah, how long will this process take, do you think?
Okay.
And what's your odds of being successful?
Well-
Obviously, you believe you're going to win this.
Elliot, I appreciate that. We feel confident that we'll be successful. One of the things that's different between this case and the Gardner case is that in this instance, we are asking the court to immediately issue a removal order pending adjudication of the merits of our claims. I'm hopeful that whatever judge is assigned will accept that offer and will do that. Again, I can't tell you how long it'll take to get a judge assigned and to get a date on the calendar for a hearing, but I would anticipate within the next 45 days we're underway with discovery.
Last question. Last question.
His attorney is saying that there's a difference between detaining someone and arresting someone, in the instance at the CJC at least. Do you draw a distinction between detaining someone and arresting someone?
Look, we can quibble over reasonable suspicion, probable cause, whether you're arrested within the meaning of the Fourth Amendment, but what we see in the evidence is that Sheriff Montgomery and his deputies handcuff individuals and transport them from one location to another. That starts looking more like felonious restraint than a lawful arrest.
Attorney General, if I
Thank
can
you so
throw
much.
one more follow-up question in there. You mentioned getting this expedited and his removal pending his adjudication. What warrants that? What damage could be done if Sheriff Montgomery remains in office?
His willful refusal to be constrained by the laws of the state of Missouri. The public is at risk if he's arresting people and disarming them illegally or arresting public officials who are in the discharge of their official duties. That justifies immediate removal. Thank you all for your patience. We appreciate you. The case is available on CaseNet.
Will you commit to future press conferences taking other questions?
Thank you. Now, all of you should have received it. If not, we can get with our press team. But there is a press release with the counts that he just detailed. And if you've got any further questions, just let us know. We will be on site.